3, 2, 1, and we are live.
All right, we are here for day three. This is indeed another interesting day of our special symposium right here from the G2K Foreign Affairs Committee. We've heard a lot of interesting conversations. We've heard different speakers over time, but this is day three. And this is our final day, and this is a time when we want a lot of people to come on, hop on, get involved as we just wrap up what we're doing right here for our foreign affairs, talking about data protection. We've spoken with lawyers, we've spoken with persons who are in the field of data and information. We've gone to the highest level. We've spoken to people at home and abroad. So man yada, man abroad. And we are going to continue that type of conversation right here with you. So you're live with us on YouTube, and we like the fact that we can bring that conversation to you. I won't tell you who the speaker is just yet. That's not my job. My job is just to say good evening to everybody. And I'm going to ask our chair, Mr. Nathaniel Moore, to do our welcome, and then we'll go into the speaker. But I want you to start curating your questions, because today we're talking about the impact of the GDPR in international trade. And for one, I am a student of international relations, so this is very interesting for me. And I hope it's interesting for you, because trade is important to any state. And as we talk about Jamaica, and Jamaica as a country that's very involved in trade, we have to look at how the different aspects of data protection affects us in that area. So good evening, welcome, share with a friend, because we have an interesting conversation for you. But for now, I'm going to turn over to Mr. Nathaniel Moore, the Foreign Affairs Chair for G2K, who will give you the welcome.
Greetings, everyone. It is indeed a great day to be alive. It is a great day to get the chance to engage in intellectual discussions. It's indeed a great opportunity to see the culmination of hard work before us. We are here on the final day of the Data Protection and Cybersecurity Symposium. And I am indeed very proud of the work that my committee has done, very proud of the work that the speakers have presented. Very proud of the viewers who came out and asked the relevant questions, questions that persons would really need the answers to, so that we can, as a nation, move forward in cybersecurity, as a nation move forward and be able to comply with the various regulations, as a nation not be left behind in the digital revolution. So I just welcome you all. I hope you all get the opportunity to enjoy the proceedings. We welcome members of the media. Well, we welcome Ministry of Foreign Affairs. We welcome members of different institutions such as the University of the West Indies, such as CMU, such as UTech, persons from ICU and other institutions that are currently in attendance. We welcome dignitaries, we welcome members from the different embassies, and we also welcome members of the organization, the G2K Massive. We're very happy to have you here, and we hope that everyone is able to learn and engage in the discussions that we're having. So I hand over to our capable and our competent, our very well-read Sanjay Roden, as he will host the proceedings.
All right, thank you so much, Mr. Chair. Thank you so much. We appreciate the welcome coming from our chair, Mr. Nathaniel Moore. I'm welcoming us to the final day, the ultimate day, day three of our Data Protection and International Relations Symposium. Now, today, unlike the other days, we are going to be in focus. We're going to be direct. We're going to move like an arrow, and we're going to go right into the issues, because what's special about today is that we only have one speaker. And that means that this individual will be able to unearth a lot of ideas, a lot of thoughts, and we'll be able to ask questions and pry into the information as deep as we need to so that we can understand what exactly we're talking about today. But I'm not giving the introduction. That's not my job. I probably overstepped by telling you that we have a speaker today, but Miss Kadian McNeil is here with us, and she'll be the one that will be introducing our special speaker as he gives us his presentation, which I hope you listen to, take your notes, and then please, we're begging you, have some questions because it will be interesting. Kadian, introduce our speaker for us, please.
Thank you, Mr. Roden. Good afternoon, everyone, and special welcome to our presenter for today. It is my utmost pleasure, Mr. Foster, to introduce you to our audience here this afternoon. Nicholas Foster has over 20 years of experience working in the data protection field, incorporating the European General Data Protection Regulations across public and private sectors. Having qualified as an attorney at law in 2002, coupled with a postgraduate diploma in law from City University London, he subsequently acquired a master's degree in information rights law at Northumbria University in the United Kingdom. Alongside his data protection practice, Nicholas's career includes lecturing positions at the South Bank University in London on advanced legal courses and at Queen Margaret University in Scotland, developing and delivering accredited courses in complaint management and alternative dispute resolution, with a key emphasis on root cause analysis, an essential tool for data breach management. Courses were delivered to various private and public sector organizations, including the Information Commissioner's Office, which is the UK's data protection regulator. In light of his academic and professional background, Nicholas is well placed to provide some reflections on the UK and European data protection experience and how businesses in the Caribbean can develop systems and processes to protect the personal information of customers and stakeholders, ensuring that they remain competitive in the changing digital landscape, coupled with the introduction of regional and international regulations and laws regarding data privacy. Welcome, Mr. Foster.
Great. Thank you, Ms. McNeil, and thank you, special thanks to the committee for hosting these events. I've watched all of the presentations over the past 2 days, and they were very insightful and informative, and I hope that everyone, and certainly every business across Jamaica, will pay particular attention to what's been said over these past few days. So I'm very delighted to join you this afternoon. For you and for me in the UK is tonight. Data protection is very important. And I've been in this field for quite some time. But I'm even more delighted to join you as a proud Jamaican born and bred. And I'll be looking forward to sharing my experience and knowledge that I've acquired over the past number of years, but also my experience in implementing and developing data protection systems in the UK and currently working for one of the largest provider of health and social care services across England, Scotland, and Wales as data protection officer and head of information governance, where we have over 100 companies, legal entities, and 500 sites. I've got a presentation which I'll be sharing with you. I'm going to put up my slides now, so let's see if the technology works. Can I just check that everyone can see those slides? Excellent. Okay, so doesn't seem to be working.
I'm seeing the first slide.
Okay, I'll try again.
Yeah, try again.
That's technology for you. Sometimes it works, sometimes it doesn't. Okay, now you can see that. Okay, excellent. Now, my fellow speakers have said over the past few days, and I'm sure you've heard this before, that data is the new oil. But did you know that it is estimated in the last 2 years, 90% of the world's data was created? So that's the reason why everyone talks about data as being the new oil. Big companies across the world, from Amazon, Netflix, McDonald's, LinkedIn, etc., are using data of private individuals as a commodity to expand their customer base and secure a dominant position in the marketplace. And by doing so, they increase their profit margin. So for example, General Electrics, they have predicted that data in the US will boost productivity by 1.5%. That's millions of dollars. And this is all because of the data of personal individuals. So it's against this backdrop that the European Union introduced the GDPR, or General Data Protection Regulations, in May 2018. Lots of people talk about the how and what of GDPR, but I would like to spend some time to focus on the why. GDPR was introduced as a result of 7 strategic drivers. Firstly, because of the rapid increase of data and advancement in technology over the past number of years, where companies, some of the companies I've just shown you on the previous slides, are using data in different ways, but also hoarding data in large amount, using for different reasons across the world. This has created challenges for personal data, where, for example, individuals, the ordinary dogs on the street, can, at the click of a button or the touch of a finger, upload to the internet personal information about themselves, about families, about other people, information that is shared across the world to millions and sometimes billions of people within seconds. So across the EU, let me focus on the EU for now. Across the EU, the European Commission thought it was necessary to have strong and more coherent systems of regulations and laws in place to protect personal data. And that's because before 2018, there were 28 countries in the EU. All these countries had data protection laws at varying degrees and various types of enforcement powers. And that's because countries implemented data protection law because of how they interpreted the previous directive. And for those of you who study law will understand what this means, but let me break it down for the ordinary person in the street, is that each country choose what to do with data protection, whether or not to take it seriously, whether or not to fine large companies, fine them maybe a few pounds or a few dollars, or lots of money. And so we have disparate systems, different system. It wasn't a one size fit all. The EU decided this doesn't work. The rules of the game have changed. In fact, it's a new game. It's a different playing field. So we need new laws in place. And also, we need to provide certainty for the ordinary person on the street. We also need to provide certainty for businesses so that they can understand if you break the law, this is the punishment. We will come after you, and we will come after you in a big way. So natural persons, as the GDPR defines this, in other words, persons, ordinary users of data or ordinary customers will have some recourse should there be any misuse or abuse of their data protection rights. And also there must be a system of trust between consumer and business, because the European Union recognized that the digital economy is essential and data is key. So it's not about stifling innovation or preventing expansion of businesses. No, it's about having ethical framework in place to safeguard and protect personal information. So in effect, the GDPR has given the ordinary person control over their personal data. It's not just data belongs to a company, it's personal data belonging to people. So the Data Protection Act, which followed GDPR, and the GDPR is grounded in the European Charter of Fundamental Rights. And this is where the protection of personal data is on par, is on the same level with the right to a fair trial, or the freedom of expression, or the freedom of conscience. Data is not just information on a piece of paper, or on a mobile phone, or on a computer screen. It's important information regarding people that must be protected. You've heard a lot this week about the 6 data protection principles, or some people refer to them as 7 principles. But all of these principles, if you imagine, they all rest on the principle of accountability. So businesses must demonstrate that they're accountable to the relevant data protection regulator. The first principle is around lawfulness, fairness, and transparency. Lawfulness simply means in order to use someone's data, to collect, to share, to process, there must be a legal text in place that you can point to say you can do this because the law says you can do it. But because the law says you can do it, it doesn't mean it can be done or should be done. So in other words, it must be fair to process someone's information. If I use this analogy, which I tend to refer to from time to time, just because the traffic light is green in your favor, you wouldn't cross the street if a speeding car is coming in your direction. That's with data protection, law, and fairness. There must be fairness, there must be proportionality. Users must expect that information will be used in a particular manner. Transparency. Those who own data subject, as the law refers to them as, must know in advance why their information is collected, where the information will be shared, who will have access to the information, and what security systems are in place to protect their information. Purpose limitation. Why is information being collected? And will information be used for a different purpose other than the purpose for which it was collected? Data minimization. more information should not be requested than is necessary to fulfill a particular purpose. So for example, if a company is conducting a survey of its employees about working practices or in terms of how comfortable they are in the workplace, there's no need to ask about what they had for dinner the previous night, or ask about are they divorced, or ask about their sexuality. Information should be relevant for the relevant purpose at hand. And of course, information should be accurate. Lots of businesses and even across the public sector collect information which is out of date by many years, but that information is still shared with other businesses or other sectors or even law enforcement agencies. And because of that sharing, there is significant and sometimes negative impact on the data subject because the information is no longer accurate. It is out of date. So there's an obligation on the data, on the GDPR, that information should be accurate, and data subject has a right to ask for information to be rectified and to object to processing until that information is rectified. Storage limitation. In other words, data should not be kept forever and a day. There is a timeline on how long that information should be kept. But this timeline is guided by different factors. There could be laws of parliament that says information should be kept, for example, financial information or HR information about employees should be kept, or medical information should be kept for a particular period of time because of X reasons. Someone may wish to bring a claim, etc. But also limitation periods for storing information should be guided by industry practice. So for example, accountants would keep information for a certain period of time, or certain financial sectors. Or it may simply be a business need for retaining that information for monitoring purposes, for auditing purposes, etc. But those purposes must be clearly stated at the outset. That's what the GDPR refers to in Article 13 and 14 about privacy notice, information that should be given to the public about how their data will be handled and used. And they're all as important, all of these principles, but indeed the integrity and confidentiality principle is even more important in terms of the focus that should be given to protecting someone's data, wherever that information is shared across borders, across companies, etc. So for example, if you're sending an email containing medical information or information about someone's criminal record or information about someone's sexuality, is that information encrypted? What level of protection is used when sharing such information? All of these points should be taken into account. So the GDPR expand its reaches far beyond its borders. It's like an octopus where its tentacles will ensnare any data controller or any data processor, whether within or outside of the European Union, providing they offer goods or services to residents, data subjects within the European Union, whether or not that service is offered freely or at a price. So for example, if businesses in Jamaica set up a website with a domain name of EU, targeting customers in the EU, and the website is written in French, and the euro is used as a currency, and the content targets European citizens, that business will be caught by the Data Protection Act and the General Data Protection Regulations. Or if that business were to monitor the behavior of residents, data subjects in the EU by tracking their movements on the internet, as in using cookies, or predicting their behavior, analyzing their marketing preferences, etc., that business will be caught by the GDPR. The GDPR does not affect or stifle trade. The European Union recognized that this is key, but there are some caveats. In other words, there are some ground rules. Trade can continue, and they'll trade with any country across the world, providing the principles of the GDPR are not compromised, and providing that country has high level of protection for data. So the EU will provide adequacy decisions for any country who they deem to have adequate levels of protection in place for data. And across the world, there are currently 11 countries with such adequacy decisions in place. The EU provided an adequacy decisions for the UK only recently after leaving the European Union as a result of Brexit, and also South Korea had a recent adequacy decision. And what this means in practice, I'll show you a few scenarios here. So if information is being sent from Jamaica to the EEA or EU or the UK, there's no need to have an adequacy decision in place because the EU has already got strong framework and systems in place for data protection, so is the UK. So that transfer will be unrestricted. However, if a business is receiving data into Jamaica from the UK or the EU, that business should be aware of certain rules and obligations that must be complied with, because the business in Jamaica will be categorized as a data importer, and the business or person in the UK or EU will be viewed as a data exporter. The data exporter from the EU or UK must comply with the GDPR and the UK GDPR and data protection regulations. So for example, one way to ensure compliance will be to have adequate safeguards in place, such as standard contract clauses, which ensure that there are binding obligations, legal obligations, on both companies should there be a data breach. And the whole objective of this is to protect personal data of citizens. But if on the other hand, data is being sent from Germany to South Korea, this is fine. It can be done unimpeded because there's an adequacy decision in place in respect of South Korea. The words of the GDPR are not just lofty or grand statements. They've got real teeth and real bite, so to speak. Recently, Amazon was fined 746 million euros for breaching GDPR. British Airways and Marriott, a couple of years ago, had a data breach, a breach of security, which was the sixth principle of GDPR in terms of integrity and confidentiality. The UK Information Commissioner fined them. At first, British Airways was fined 183 million. They appealed that, and due to COVID, it was reduced to 20 million. Marriott was initially fined 99 million. Again, this was reduced following appeal. Google was fined, as you can see, 50 million euros. And this happened for transparency reasons in terms of how they process data and also failing to have a legal basis in place in terms of advertising. Twitter was also fined in the early days back in 2019, 450,000. And the regulator at the time, that was 2019, said that fine was a sign that the teeth of the GDPR is getting sharper. So that means the recent fine of 746 million against Amazon means that the teeth are very sharp. So any company who falls foul of the GDPR should watch out, because these laws will come after them strongly. Now, people across the world and in the Caribbean, in Jamaica, may be wondering, what's the status of the UK post-Brexit? But the UK has always had robust data protection systems and framework in place, including dating back to the Data Protection Act of 1984, and then followed by the Data Protection Act of 1998, upon which the Jamaica's Data Protection Act of 2020 is based. The UK introduced in May 2018, on the same date, 25th of May, when GDPR was introduced. UK introduced our own Data Protection Act of 2018. And this law mirrored virtually word for word all of the GDPR. That's why after Brexit, the UK government has incorporated all of the GDPR, except a few minor tweaks, all of the GDPR within UK law. So the UK law is on par with the rest of the EU when it comes to data protection. And also, the UK's Information Commissioner is very assertive in championing data protection rights. Recently, the Information Commissioner has taken firm action and imposed financial penalties on companies for nuisance telephone calls and also unsolicited marketing. The Information Commission is also issuing guidance and setting the standards when it comes to artificial intelligence, and also the use of police forces and different law enforcement organizations with personal data in fighting crime. The UK also has strong jurisprudence from case law in clarifying legal texts when it comes to data protection. And there's a criminal offense in place under UK law for unlawfully obtaining and retaining personal data without consent, and also deleting personal data because of a request to access information. So we've got strong systems in place, and long may that continue. So I'd like to share with you now some reflections from the implementation of GDPR across the EU and also across the UK. Because as Jamaica is embarking on its data protection journey, I hope that some of these reflections will help to shape future direction. Terminology is quite important. Indeed, it is very important. Personal data, most people understand to mean information that will identify someone. In the Jamaican law, personal data is broader than that definition. It includes someone who has been deceased for under 30 years. And there'll be different variances and nuances to this definition across the world. But what we have found in the UK is that legal case law was essential in clarifying some of these definitions. So back in 2003, there was a case that went to the appeal court, and this was a case of Durant against Financial Services Authority. Mr. Durant made a subject access request to his bank for his personal data. The bank provided him some of his data, but not all. They didn't provide him information that was held in manual systems because they didn't think that was his personal data. He appealed to the court, which subsequently reached to the appellate court. The appellate court decided that for information to be personal data, it must have biographical significance to the data subject. In other words, that information must describe the data subject in some way pertaining to his or her characteristics, activities, behavior, etc. Just the mere mention of someone's name on a piece of paper doesn't automatically mean that is their personal data. I receive requests from time to time from employees wanting to access their personal data. And there is a misunderstanding that because they've sent an email with their email address or their signature with job title at the end of the email, that email should be automatically be disclosed to them, but that is not correct. And the court goes on to say that for information to be personal data, the data subject must be the focus of that information. There must be some link where that information was created with that person as his focus or intent in mind. Subject access requests. There used to be a charge under the Data Protection Act of 1998 of £10 to access such requests. That's not the case anymore. Requests used to be made only in writing, but that's not the case anymore. Requests can be made orally or verbally. In Jamaica, under the new law, there is suggestions about charges, a tiered level of charge for some requests. Those could present challenges. And also, when a subject access request is made, one should consider where is the information held? How long is that information held? Is it held in structured systems or manual systems? A good word of advice or tip may be useful for businesses to consider recording data with a view to releasing that data in 6 months or a year's time as a result of a subject access request. Because as soon as the public become aware of their rights under the law, there will be an exponential increase in requests to companies. So Do you have the resource in place to handle these requests? You have the processes in place, the policies in place, the staff in place, also systems. There is talk in the data protection law about a mediator to deal with complaints from data subjects. That's a useful development because complaints will be coming. Many people will misunderstand what they're entitled to. So it's important to have a framework in place so that dispute can be resolved easily. Requests will be made from different quarters, but also requests will be made during legal proceedings. So one needs to consider the interface between the Data Protection Act, where there's a right of access, to a right of access where there is disclosures which are made during legal cases. It's also useful for information sharing agreements or protocols to be in place where there's routine and regular sharing of data across organizations, including across the public sector. In the UK and under GDPR, a data protection officer is not mandatory. It's only used where there is a large scale processing of personal data, as in lots of sensitive data, medical records, criminal conviction records, is used massively. A data protection officer is required. Under the data protection law in Jamaica, there is a data protection officer will be required in some instances, but also the data protection officer will be required to report contraventions to the Information Commissioner if those contraventions are not rectified within 6 months. Now, there would be a potential conflict there where the data protection officer could be effectively required to spy or to grass up, as the street slang is, on their employer, who is also paying their wage. Data protection office impact assessment is used only in certain instances in the UK and across Europe. And that's only where there is a higher risk of processing, where the data subject could be at risk if there's a breach in a real way, in a personal way, or in a financial way. In terms of notifying data subjects of breaches, that only happen in some cases, again, where there's a high risk to the data subject. So for example, if there's a breach where there's a risk of identity theft, then obviously the data subject should be informed. Where they could be at risk physically, etc., they should be informed. But there where there's a risk which is classified as medium or marginal, there's no requirement to inform data subject of breaches. It's also important for businesses to consider what actions and what safeguard can be in place to prevent breaches from happening in the first place. As the saying goes, prevention is better than cure. What safeguards are in place? Are there encryption devices in place? Are you preventing your staff from using USB stick? What level of protections in place to prevent breaches other than just training? And vicarious liability. There was another case in the UK where an ex-member of staff used to work in finance, uploaded to the internet 100,000 records of different individuals. That company was fined by the Information Commissioner, and the appeal, it went to the Supreme Court, who ruled last year, April, that a business is not liable for the deliberate actions of a disgruntled employee, providing that business has taken adequate steps to prevent data breaches. As been said over the past few days, data protection laws across the world have been developing thick and fast. Some of the key strategic partners and certainly trading partners have developed data protection laws. Partners with which Jamaica will need to do business in order to thrive, and certainly in order to come out of this pandemic as a strong economy. So from India to China, they'll be implementing their data protection law on the 1st of November. From the EU, from Brazil to Canada, and even states across the US. And there's talks of having a federal data protection law. So in order for trade to continue unimpeded, it is important for data to flow across countries, across regions, across continents. So businesses in Jamaica, it's imperative for you to carry out records of processing activities, as in ROPA. Map your data. Do you know where your data is held? Is it on paper? Is it electronic? Is it in cupboards? Is it in garages? Is it in someone's house? Where is it? You know, who has access to it? It's really important for this to be clarified and for robust systems in place to protect that data, and also so that you can evidence your practices. But also, is information being stored in the cloud? Where in the world is it held? What safeguards are in place with those cloud providers? Are there penetration testing carried out? Are they cybersecurity compliant? And also in terms of contracts, do you have up-to-date contracts with your data processes? What about your employees' contracts? Are there clauses within employment contracts so that staff are aware of their data protection obligations and also the implications of them flouting your policies or data protection expectations in your company? What territory are you doing business with? What is your data protection expectations and obligations for trade? Have you updated your policies, not just data protection, information security, rights of access, etc., to ensure compliance with the new law in Jamaica, but also of your trading partners and also trading bloc? And also in terms of transparency, which is key. How much do you promote what you do, your good practice, to customers? And also, are you explaining to customers exactly what you will do with their data and how they can access their data? Because customers and consumers and citizens are becoming more and more savvy. They understand that their data is not just information on a piece of paper, it's actually a useful commodity in the hands of companies and big businesses. And a recent study has shown companies more and more who've got strong data protection systems and practices in place. Those are the companies that customers will be going to more and more to do business. So it simply means that companies who don't have good systems in place will be left behind. And when it comes to data protection, customers are looking for not just grand statements, not just laws, but also ethical approach in terms of how they handled data. So I started off by saying that data is the new oil. But in order to flourish and to thrive in this information age, trust is the new gold. So I hope you found that useful. I'm open for questions or to have a conversation further in terms of how we ensure that the relevant safeguards are in place to protect data. Thank you.
All right, thank you so much, Mr. Foster. You know, I had to be taking notes just to ensure that I could follow all the information. I'm asking questions along and hopefully I'll get them as soon as possible too. I'm looking at the presentation and I learned a lot. I have written certain things down. As a matter of fact, Mr. Foster, saw that you set out 6 specific.
That says information should be collected and this information should be held for 2 years, 5 years, 10 years. That's fine. But if there's no law in place, that information will have to be deleted. And that's what's referred to under the GDPR as the right to be forgotten, right? It's the right of erasure, yeah, for information to be deleted. Now, in terms of for future, where businesses ask for irrelevant information, or anyone asks for relevant information, the consumer, the citizen, has a right, because they've been empowered with these new rights, to ask, why do you want this information? Give an explanation as to your justification for asking for this information. And unless there's a justification for it, that information shouldn't be provided or certainly can be withheld.
I think to push back further on that, Mr. Foster, I think people would want to know, because we know with big technology companies and the rest of it that they are very, they're very protected. They have their lawyers ready. They have everything in place. So sometimes you come at them and even if you're in the right, they make it a bit difficult. So what if after those 30 days, or if they push for an extension, 60 days, they do not provide that type of information that you have the right to? But in that sense, they're fighting it. They're fighting it because they would not want to lose that battle in court. So they're fighting it. What can somebody do then? As the attorney at law, what would your advice be?
Yeah, so you see, that's where the teeth of the GDPR comes into play. Yeah. So it's no longer just a barking dog, it's a dog that's ready to bite. Yeah. And so if the business won't comply, won't play ball, right? The customer complains to the Information Commission. Yeah. There's no charge to making a complaint to the Information Commission. The Information Commissioner then will enforce the law. And it has a big stick where the Information Commissioner can fine that company up to either 2% or 4% of its annual turnover. Yeah. And we know companies watch their bottom line. Companies tend to listen and take notice where money is involved. And so you make a complaint to the Information Commissioner, and the Information Commissioner will take action. But also, in parallel to that, the consumer can also go to court. Well, that is the last resort, because going to the court will cost money. Yeah, and it takes time. It will certainly take longer than 30 days or 60 days to receive a remedy. So go to the Information Commissioner and action will be taken.
All right, thank you so much. Thank you so much. I noted that you spoke to us a little bit about encryption and the importance of encrypting very sensitive data, especially data about some specific things that individuals might be asked to do when you're signing up. When you sign up for a lot of things, you get that long agreement that you have to sign, whether it's for your email, whether it's for a company, whether you're signing on to just become a part of something. There's a long agreement that you have to sign before you, well, after you fill out a form that has specific information or data that they want to collect, right? So a question that I have based on that backdrop is, what are the legal ramifications if an individual's encrypted data is breached? What are the legal ramifications for a company or institution that would have collected that type of data? It should be encrypted at the highest level, but it is breached.
So are you referring to someone tampering with the encryption, or the information is not encrypted?
Both cases. Both cases.
Yeah. So in terms of the first part, where information should have been encrypted and it wasn't encrypted, then that's a breach of the 6th GDPR principle around confidentiality and integrity of the data. Because under GDPR, just to expand on that, it really means that organization should take appropriate technical measures to protect data, based on the state-of-the-art technology, etc., and current development. And encryption could be from just a encrypted key, where the recipients receive a particular code, or multiple factor authentication, or etc., or just password protecting a document. Right? So a company would be negligent and certainly reckless for not taking action to protect sensitive data. And under GDPR, they will be liable to be fined a lot of money. And you've seen some of the examples I've given in terms of companies that's been fined. And one of those companies was fined, I think it was Twitter, for failing to notify the information commissioner of a data breach within 72 hours. Lots of people would see that as a minor infraction, but nevertheless, that was taken seriously. So imagine where a company failed to encrypt information that should have been encrypted, they will be subject to certainly a massive fine. And certainly where encryption is broken or tampered with, then under UK law, and there is the Computer Misuse Act, and also different Telecommunications Act, where some of these involve criminal offenses, where the police will be calling to investigate, and the culprit will be held accountable.
So as it relates to, so as it relates to, you said UK law just now, and you generally told us in the presentation about how the UK had kind of mirrored the GDPR to facilitate its data protection bill, which was done in 2018. And you said that was, I think that was pre-Brexit, and then you have post-Brexit, there were some ramifications to that. So what similarities are there, if any, similarities between what we've been going through, the Data Protection Act in Jamaica 2021 and the Data Protection Act of the UK 2018?
There are some similarities in terms of access request. In terms of the data protection principles, the Jamaican law referred to them as data protection standards. I refer in my presentation to record of processing activity, which ought to be carried out by a relevant business. In the Jamaican law, they refer to as the particulars of the data protection should be compiled particulars of data processing should be compiled and sent to the Information Commissioner in Jamaica. Now, that's, as I said, the Jamaican law is mirrored on the UK data protection law of 1998. The UK has moved on from that because companies no longer send processing particulars to the Information Commissioner. That is done and held locally. So therefore, it's less onerous, certainly for businesses, but also for the Information Commissioner, so as to not be inundated and being able to sort of focus on sort of enforcing the law in a real way. Access requests is also similar to data protection law in the UK, but only that there isn't a charge. We don't have a tiered charging structure. Data protection impact assessments are carried out in the UK, but only where there's a sort of high risk, of processing for data subject, as opposed to all, data protection impact assessment for all types of data. So there are some similarities on the previous law, 1998, and there are probably fewer similarities in terms of the current law, but nevertheless, the law is still robust in terms of starting out of the block, so to speak. And another area where I think there's variance is around penalties, where under the UK law, there's a criminal offense of unlawfully obtaining and retaining personal data that could carry a stiff penalty. So far, only one person served a custodial sentence of around 6 months, and that was the example I gave you, where someone uploaded records of 100,000 employees to the internet. But generally, there isn't a custodial sentence for GDPR data protection infractions in the UK, whereas in Jamaican law, there are huge financial penalties, rightly so, but also there are some stiff custodial sentences, which is a big difference.
Thank you so much. So a lot of persons have been hopping on and off, and we see our viewers coming in and out. But just for them to understand a bit, I just want to tap into Mr. Foster's life, into his personal life a bit, into his career life, just to understand where exactly did you start? How did you get into data protection? Why was this the field to choose? And basically, how has it been? What has it been like for you being a part of data protection, seeing everything that's happening around the world as it relates to data, the fact that, as you said, data is the new oil, big data. Data can be sold. I can sign up with my email address for a service from a company, and then another company starts emailing me, not knowing that I agreed to some terms and conditions for my email to be shared. So how did you get here, Mr. Foster?
Well, it's been a journey. And so I'm a lawyer by trade, in terms, as I was called to the bar in the UK and got a law degree. And so I've been working in the public sector since around 2000. And in the public sector, within health and social care, where there's a lot of sensitive information, about people care needs or people health conditions. So that's where it was piqued my interest around confidentiality. Yeah, it first started wasn't around data protection in the broader sense of legality, but around confidence, keeping information confidential, which linked to my legal study about the common law duty of confidentiality, which dates back many, many hundreds of years. So it's data protection is maybe new for some people, but in terms of the principle has been around for a long time. has been said over the past few days. There's a distinction between data protection and data privacy, you see. So having done that, I've been working in the public sector, handling access requests from individuals wanting to access their records, going through files, redacting information, withholding information that relates to other people's data or business sensitive information, then managing a team and then training a team of staff, handling subject access requests, but also on the flip side to this, there's also the freedom of information request, which many countries don't have this, but it's been a law in the UK since 2000, where any member of the public can make a request to a public body to ask for information about financial matters, about the running of public services, about expenditure, how public money is spent. The people has a right to access and see that information. So I've been involved in all of that. Then I completed my master's degree in information rights law, covering all of those regimes, access regimes for environmental information, freedom of information, data protection, etc. And at that time, when I was doing my master's degree, the GDPR was in its embryonic stages in development. And it was very insightful to see the draft text and to see what a game changer it was going to be. And that's how my career developed over the years.
Oh, so just to pry a little bit more, how has life been like in the diaspora in the UK? It's you're originally Jamaican, and you can see my flag in the background, of course.
So, I've got mine in the next room.
So how has it been like being in the diaspora, practicing data protection, but being a Jamaican, being abroad and practicing, living, doing what you do best? How has that been for you?
It's been very, very transformative. It's been productive. I'll say to all of those Jamaican listening out there now, or whether you want to replay this video at some point, we've got the foundation to thrive and to succeed in any country across the world. We've got fantastic education system, fantastic teachers, without the frills, of all of the sort of latest technology or the best playing fields or best desks, etc. We've got fantastic teachers, and that grounding gave me the confidence and the ability and self-belief to thrive in the society and to operate and par with anyone who's gone to Oxford or Cambridge or certainly the top universities across the UK. So it's been very useful, and it's been worthwhile, I would say.
Right. So I have about 2 final questions coming in. I think after that I'll turn over to the chair if he has any questions.
Yeah.
To the Foreign Affairs Chair, but I have just about 2 more questions. I listened to your presentation. It was in depth, and I think that it covered a lot of bases. When a presentation is good, when it covers a lot of bases as it relates to the European concept and basically the UK. Now, the question is, as a Jamaican in the diaspora, why, you said why. You said we're talking about the why today, but why is the GDPR important to a country like Jamaica?
Well, that's because the world is no longer fragmented, so to speak. We're living in a global world. The internet has made the world smaller, and COVID has certainly even made it much more smaller. So we are interdependent on each other. you know, we can share information within a second, but also in terms of doing business. It's been said, I'll repeat it again, data is the new oil. Business these days is no longer working on the farm for hours in the sun. You know, some people still do and make a good living. We need all of that, food, yeah, of course, yes. But most business is now done virtual. Yeah, and COVID has shown us that. You know, we can trade with someone in the far-flung parts of the world, you know, in Africa, in India, in Australia, you know, that makes it a small space. So therefore, GDPR is a game changer. You know, it's the most robust and sort of strongest mechanism in place to protect data across the world. It was one of the first. And lots of countries across the world has used the GDPR as a model. And certainly lots of countries across the world were woken up when they read about the GDPR because they know what's coming. So it's important for business in Jamaica, you know, to wake up because, you know, trade will not happen smoothly, certainly, may happen, take a long time, etc., with lots of legal challenges, you know, but trade will not happen smoothly without strong data protection, strong and ethical data protection systems and framework in place.
Yeah, as you mentioned, the legal side, that ties right into my final question to you, because I am a proponent of realism and whether or not international law actually works. Now, you'd have noted earlier, specifically countries that have been fined, states that have been fined, and companies also that have been fined based on what would have happened as it relates to data. And before we started the conversation on YouTube, you and I were talking a bit, and I was talking about what would have happened with a data breach sometime last year. Now, as it relates to legal obligations that bind states across the world, what exactly can states do in the aspects of whether or not there's a breach between states in international law when it comes on to the GDPR?
The GDPR it provides legal recourse to individuals, yeah, first and foremost. So it is a law to protect personal data and the data of individuals. So it is really for states to ensure that their citizens are aware of their obligations, their businesses, their companies, etc., are aware of their obligations to protect personal data. So the law doesn't really provide recourse for states against another state.
Right. So just to push on that, Sir Foster, so it doesn't provide states v. states as it relates to that type of interaction. So how would that state, especially a developing state, what is there in probably international law as it relates to data and their protection? Because you spoke to the interaction between probably one of the 11 states and another state and how there is that protection that exists. So I'm trying to understand really, what kind of state protection exists if it's an interstate relationship and somewhere along the line, there is some breach.
Yes. So in terms of the person who is responsible under the GDPR is the data controller. Yeah. So if the company is the data controller, they will be liable. If the state is the data controller, they will be liable. So if for example, and let me use another word in terms of the organ of the state. So if the health ministry has breached data that comes from a EU citizen, then the health ministry is responsible because the health ministry is the data controller. Yeah. Or if the health ministry has sublet, their responsibilities to another organization, then the data processor and the health ministry will also be liable. So that's how it works, So it's not necessarily, Jamaica against France or this country against another country. It's about who is the person who is responsible for determining how that information is processed, for controlling it. Who is the data controller? Who is making those decisions? So that's where the buck stops, so to speak, on the GDPR. Of course, there are wider implications in terms of diplomacy and trade laws, etc. But in terms of the legal cold text of the law, the person that will normally be in the dock is the data controller.
Wow, thank God I didn't do my degree in IT and I didn't become a data controller, because that sounds like a lot of pressure. And I totally understand where you're coming from, Mr. Foster. I think that's my final question here. And I hope the chair is here with us. He should be on with us right now. If he has any questions or if we're going into a vote of thanks, he will guide me accordingly. But yeah, that's pretty interesting. And I want those watching right now to note that it wouldn't be government versus government, but it would really, based on the GDPR, would go back to what really happened when you were coding, what happened when you were trying to encrypt this data. And that's very interesting. Thank you, Mr. Foster. You really enlightened me this evening. But Mr. Chair, I don't want to say too much now. Mr. Chair, I'm handing over to you really quickly before we come to a close.
Good day again. I have a question. This is a recurring question that I have tried to ask at least once during each of the presentations. So this is in relation to smaller companies and complying with the regulations that are in place. As we have noted, the Jamaican Data Protections Act legislation is very similar to the GDPR in various aspects, which means that the requirements that are in place, most of these requirements, the Jamaican companies, Jamaican persons would have to comply with. So the question is, what are the cost-effective solutions to ensuring that there's compliance? Let's say I can't necessarily employ a large data protection company that's going to come and handle the business for me. What are the cost-effective solutions that small business in Jamaica can utilize?
Yeah, thank you. That is indeed a good question. So the very essence of GDPR is about risk management. Yeah. The first and foremost, what's the risk of that processing activity to the ordinary person on the street whose data is being processed? Yeah, that's the main issue. So if a business should have kind of approach that, yeah, from a risk analysis. So in other words, and sort of grade their risk accordingly. Some businesses got a bigger risk appetite because they've got deeper pockets. Some don't have any risk appetite, etc. So what's the most important thing for you as a business? Because like you've said, it might be a small business who doesn't process a lot of data, but also it's not necessarily the amount of data that's processed, but it's the type of data that's processed. So if you process lots of sensitive data, and under the GDPR and most data protection laws will describe sensitive data as medical records, criminal conviction, sexual offenses, etc. political opinions. If you process lots of sensitive data, then the advice is focus on minimizing your risk of that data first. Yeah. Identifying where the information is, identifying who you're sending it to, and thinking about how you can protect the information from a data breach. Go to your, your frequent customers, make sure that they understand what you're doing. Yeah. So it's about taking a step-by-step approach, a risk-based approach to sort of, not run before you can walk, as they say, but do it step by step, focus on the bigger ones, the ones that will let you lose most money, put a hole in your pocket, focus on those ones first, as a business, and then you will do the rest. When GDPR was implemented back in 2018, right, the approach that we took is that GDPR compliance is a journey. It's not a sprint. Yeah, it's a journey. So as long as you start on that journey, then at least you're making some progress. And compliance is not an activity. Yeah, so it's not like an event that you achieve compliance because the Jamaican Data Protection Act become law, say for example, in June 2022 or July 2022, and then all of a sudden you're compliant. No, compliance is also an ongoing process that needs to be refined, that needs to be updated as you know more, as you process more data, as new laws comes out, etc. Yeah, it's a continuing process. So my advice would be to at least start that journey with the highest risk data, and that will be a good step in the right direction.
Thank you for that answer. And I have another question. Can getting written consent from the data subject? Basically, can you have someone sign a waiver in relation to the information that you are collecting? Can a company rely on that mechanism to protect themselves from any legal action?
That's not recognized on the data protection laws, certainly not recognized on the UK or European law, because consent has to be freely given. Yeah, that's the legal definition of consent. It has to be one of those companies that was fined. They were fined because there was not free consent that was used. So if a company is putting a consumer under duress to sign an agreement or to sign away their data protection rights, that would be invalid because consent is not freely given. Yeah, the data protection rights, as I presented in one of the slides, is on equal footing as all other fundamental rights. So you can't sign away your right to a fair trial. You can't sign away your right to freedom of expression. That would be against natural justice. And any court in the land would strike down that clause as invalid.
Thank you. And this last question has two parts. So firstly, under the GDPR, would credit card and banking information be considered as sensitive data, which would be under the Act? And the second part of that question is, if it is considered such, can a person who had recently used, let's say, a card at a store that stores the credit card information or the banking information when they use their card to pay for an item, if they realize that someone else has accessed their banking information and use their cards um, under these data protection acts, um, could a company be found to be liable if that information is leaked?
Yes. Yeah. So the first part of the question was about the sensitive nature of credit card details. So under the GDPR and UK law, financial information is not described as sensitive data. It's not described as special, which is a new terminology under GDPR. So sensitive data, which is used in the Jamaican Act, is a terminology that's taken from the UK Data Protection Act of 1998. So that terminology has sort of morphed or evolved into special category data, right? So special category data is include biographical, biometric information, you know, so the DNA, medical, criminal, conviction, and also there's a special protection for criminal conviction records. But financial information is personal data, yeah? It's not nonetheless, and it should be given protection. So if there's a data breach for which the company is responsible, then the information commissioner will come after that company, yeah? And especially where information is leaked about someone, that someone could be at risk. So one could be at financial risk of losing lots of money, but also in terms of, cloning, identity theft, etc. Then the information commissioner is likely to take that very, very seriously indeed. So companies should be very extremely careful about how information, like the one that you just described, is protected. And there are also some other laws which are specific to the financial industry when using credit card information. Because, as you know, and listeners and watchers will know that more and more transactions are taking place, online. People pay for items using their mobile phones, an app on their phone, or, etc., or entering their card details into websites. So that's the reason why, that data protection principle around integrity and confidentiality is so important, because any breaches of that kind of information, companies will be liable.
Thank you for that, because a lot of these issues definitely arise with how easy it is to access information and how much data we give just in our regular daily lives. Even right now, we have many persons who are complaining that their banking information, their personal information is being sold on the black market, and they're saying that it doesn't feel like they're being protected enough by the banks and by other institutions. So this is definitely an issue that many persons are having. So I'm going to hand over to the host, and the host is going to say his final words. Before doing so, I see your background image. I see your background image, and I wanted to give you the opportunity to just tell the people at home a bit about the company.
Excellent, thank you. By the way, can you see what the business name is?
Yeah. I can see it for sure.
Right. So that name is actually named after a district in Jamaica, in St. Ann, which is called Alva. And I've just literally bit of play on words, called Avla, business services. And that's where next to where I grew up in Jamaica. So I'm a proud Jamaican, even in my company name. There's a Jamaican element. So this company, I've set this company up to provide consultancy services to businesses across the UK and also in Jamaica. I look to relocate to Jamaica to assist, as part of that journey to ensure that there's a mature data protection system that's developed going forward so that Jamaica is well positioned strategically to have a strong place in this global market. So this consultancy services is there to provide advice and guidance and training. My tagline, is about creating and delivering practical solutions, not, solutions that's pie in the sky. But it's about being pragmatic to focus on what can be achievable and how it can be achieved, covering data protection, covering dispute resolution, as well as different access regimes. Thank you.
All right, thank you so much, Mr. Foster. Thank you so much. I'm elated. I am happy that we could all come here despite virtual. And if it was a physical space, we'd need to fly Mr. Foster down to come and talk to us. But we're here in a virtual space, and he graced us with his presence. I'm explaining to us the different things that we need to understand, especially about the why, which I think is important. If you follow the thread of the past 2 days of presentations and questions and answer, you'd see the importance of why we needed today to hear about the why, the GDPR, the necessities, the what does it help us to understand, and how can we move forward understanding why it is in existence, and how it also aligns with the data protection bill of the UK, and how that data protection bill aligns with the data protection bill that we're seeing being passed in Jamaica. It has been a riveting discussion. I have learned a lot. Personally, I really, really, really learned a lot. And trust me, my understanding over the last 3 days, there are some things I really never knew. And honestly, coming today to hear and understand the why and to ask specific questions with the expertise that Mr. Nicholas Foster would have brought today. And he has his consulting business, which he told us about. I want to thank you guys so much for joining us. I want to thank you guys for just being here, and for those who will be watching after, because this video, Mr. Foster, will be left on YouTube for those who want to watch after. So we'll leave our series right there on YouTube on the G2K Jamaica page. It will be there for you to go back, look at, and understand what it is we try to unearth. And media houses have been in tune with us. Specifically, we want to big up Nationwide. We know for sure they were in tune with us, and they mentioned what would have happened in the past 2 days. And we're hoping that will be mentioned as we go along. Today will be mentioned as well, because they have been on with us, and other media entities. We want to thank them as well. This has been the final day. We want to give special thanks to our speakers over the period of time where we've seen speakers locally and internationally, UK, US, Jamaica, Middle East, wherever you want to name it. We got speakers that are experts in this area, because we can tell you, like the people with the vaccine information, even though they didn't study virology, we can't tell you about data protection. We have to get the experts, and that's what we did. So I'm just going to allow the chair to do his final thanks, but I just want to thank you guys from near and far, from home and abroad, for joining us for this data protection and international relations symposium. We want to thank you so much. I'm Sandra Rowe, and I'm going to hand over to the chair as he gives his final thanks. And after that, that should be a wrap.
Yeah, I'm going to put a bow on this symposium, and it is quite symbolic to have a Jamaican born as our final speaker for this symposium. And it's very encouraging to see a Jamaican go overseas and establish a company in the digital era, something that caters to the needs of everyone right now. And I really do pray for prosperity and only good things for your business. And I really do hope that when you come to Jamaica and you get to entrench here and start to advise companies in Jamaica. We definitely look forward to having you come and share some information. Before we had even started the forum today, we're having a conversation about the information regarding data protection reaching the masses. And that is a very important discussion that we have to have. As G2K, we do really want to encourage the government to engage the Jamaican people more, to have discussions like this. We are entering the digital era. We cannot ignore that any longer. We are here. Everyone has a phone currently. Everyone, when they enter any social media account, they do give consent to these companies taking their information, going through their contacts and their photos. And there's not really much that we know about it. There's not really much that we understand. And we just click the box because we just want to log in. So we need to have more discussions like this where information is shared. This entire symposium has been a success from the very first day to the last day. And I must firstly thank a capable and competent committee. From the committee, I must give a special highlight to Shamon King. She was really the point person who really directed the ship and carried us through the voyage here to our destination successfully. I must also thank the G2K management team, the vice presidents, the president, for their support and encouragement throughout this event. Must thank the G2K massive as well to all the chapters from the west to the east. And we are very grateful for you all coming out and attending this event. To Jamaicans at home, for your comments, for your words of encouragement, for everything. We really do appreciate that, and we do appreciate the support that we have been getting from across the globe. I had gotten the chance to look at the algorithms, and I realized that we had persons who are attending from the UK, America, India, and that is something that is truly encouraging. And we do hope to have more forums like this, more symposiums like this, so that we can gather brilliant minds in different areas to engage in discussions like this. Mr. Foster, I must thank you. Of course, I must thank you. You're the lone batsman in the wicket, and trust me, you defend it, man. You defend the flanks. You definitely defended it, man. And I really do. I think that you and the host had a really engaging discussion, and you held your own. You didn't back down. You really.
Well, as the saying goes, we look what we tell, right?
Look at what we tell. That is it. That is it. Jamaican to the core, you know. But I do appreciate you coming here. I do appreciate you attending all of the sessions that we've been having so far, and I do hope that nothing but good enters your life. So I'm going to close the door on this sensational symposium, and I do hope that everyone who did not get the chance to watch this symposium live gets the opportunity to watch it on YouTube after. The information is there and it's for free. I don't think a lot of persons even understand that your consultation fee, people didn't have to pay your consultation fee to get all of this advice from you today. And trust me, that is something that I definitely appreciate. So I am going to close the door on this event, and I do hope that everyone has a magnificent, sensational, prosperous weekend filled with opulence and opportunities. Much thanks.
Well, thank you both, and thank you for the committee. Okay, take care. Goodbye.